Judiciary Committee will come to order. The clerk will call the roll.
Mr. Chair, you have quorum.
Okay. Thank you. Yeah, Senator Dees will explain
Mr. Chair,
what we're doing here.
Senate Bill 497 from Delegate Mullen is identical to a Senate bill from Senator Obenchain that reported out of this committee 15-0, and the Senate 40-0. Senate Bill 1130 from Delegate Helmer is identical to Senate Bill 207 from Senator Peterson. You want that one out of the block? Okay. The Helmer bill's out of the block. And then the other one is Senate Bill 1145 from Delegate Leff, which has to do with civil actions, health care bills, and records, identical to one from Senator Stanley. Senate Bill 633 reported 15-0 and 40-0. So House Bill 497 and 1145, I'd move in a block then. I'd move to report those bills.
Any discussion? Okay. Any discussion? All in favor of reporting those bills? The two are Senate Bill 497, 1145, and
It's
just those two.
Just those two.
All in favor of the motion to report in a block, vote aye.
Aye. Yes.
Ayes 12, no zero.
Okay, Mr. Chair, House Bill 821 from Delegate Torian is identical to Senate Bill 6 from Senator Servelt. It passed this committee 14-0, and the Senate reported from Finance 12-4, passed the Senate 35-5. It increases from 6 to 7 the maximum number of authorized judges in Prince William County, I think, in 31st Judicial District. I'd move that we report and re-refer that bill to Finance.
Is there a second?
Second.
Any discussion? All in favor of the motion to report Senate Bill 421? Is that it? House Bill 421. All in favor, vote aye. All opposed, no.
Ayes 11, noes 1.
Okay. 11-1.
Okay, Mr. Chair, House Bill 1130 from Delegate Helmer is identical to Senator Peterson's 207, reported from this committee 15-0, the Senate 40-0. It removes the requirement that a sworn law enforcement officer be employed in a full-time capacity at the time of his retirement to purchase his service handgun, and I'd move that we report the bill.
Substitute motion.
Yes, substitute motion.
Pass it
First of
by.
all, is there a second to the motion to report?
I'll second that.
It's been moved and seconded. Senator Norman.
Pass it by indefinitely.
Okay, Senate Bill, is there a motion to pass it? Is there a motion
And a second.
and a second to pass by
Whoa,
indefinitely?
whoa.
Yes, Senator Peterson.
Okay, this is the bill for law enforcement officers to purchase their service weapons. We've passed it unanimously 2 years in a row, so.
Mr. Chairman, we have that bill, and it's over in front of the House, and I think we just need one bill.
Okay, well.
You've
I
got
can't
substitute-
support the motion.
You've got a substitute motion on the floor.
Substitute motion to pass House Bill 1130 by indefinitely, moved and seconded.
Indefinitely.
Definitely.
I'm going to defeat these guys.
All
Not
right,
that I'm a helper.
any discussion? Are you ready to vote? All in favor of the motion to pass it by indefinitely, vote aye. All opposed, no.
Ayes 2, noes 11.
Go back to the, Mr. Chair, we go back to the primary motion now.
Primary motion is to is to report the bill, House Bill 1130, which we've already reported in the form of a Senate bill. All in favor of the motion to report the bill, vote aye. All opposed, no.
Ayes 12, noes 1.
12-1. But the bill is reported.
Okay, Mr. Chair, the next block of bills begins with, do you want to go to the sheet, or you want to do the bills in order?
Why don't we do the sheet here?
Okay, the next bill is 496. It's similar to Senate Bill 687, which was from Senator Mason. It reported 14-0 to 1 and passed the Senate 37-3. I think Senator Stewart abstained from it.
Mr. Chairman, I think that was bill that Senator Mason and I brought. I don't know whether the delegate has any objection to conforming that to the manner in which it passed the Senate, but that would be my inclination to move.
Delegate Mullen, House Bill 496.
Then I'll second the motion. I'll second the motion to conform.
All right, so motion to conform House Bill 496 to Senator Mason's bill, Senate Bill 687. Any discussion? All in favor of the motion, say aye.
Aye.
All opposed, no. Motion carries.
Now, Mr. Chair, this is a bill the Finance Committee's asked for, and so I'd move the report and refer to Finance.
Okay, it's been moved and seconded. Is there a second?
There was.
To report and re-refer to Finance, House Bill 496. All in favor of the motion, vote aye. All opposed, no.
Ayes 12, noes 1.
Good to see you. The next House Bill 646,
You-
motion carries.
You want to take up Kathleen Murphy's stuff?
All right, Kathleen Murphy, would you like to present your bill? Which number is that?
Senate Bill 990, or House Bill 993. This is similar to a bill that Senate Bill 440 from Senator Boysko. I understand Delegate Murphy's got witnesses, and we've heard this bill extensively. We'll
Oh,
take
I
a-
see, 993.
Yeah, we take another minute of testimony. That's about it.
Okay.
Okay, Adam's father is here, and he would like to address this.
Just for a minute.
Yes. Okay, his aunt is here.
You go ahead, huh? Your name?
Just going to take a minute of your time. So you already know who I am. I'm the cousin of Adam Oakes.
I'm
And
sorry, you're who again?
I'm the cousin of Adam Oakes. My name is Courtney White. I've testified in front of you before. I don't want to take much of your time, but I do want to explain the importance and what happened as far as the bill. Adam's story is not the first in our state, but hopefully it will be the last. 10 hazing-related deaths have occurred in the state of Virginia, over 100 nationwide in the past 15 years. The perpetrators walk with a simple slap on the wrist. They are able to graduate and continue on with their lives, even though they participated in the deaths of innocent teenagers just trying to fit in and make new friends. Those who haze don't care about the criminal charges because it's a misdemeanor and all they receive is probation. They don't care about the civil suit where the only impact is on their insurance companies. Where is the individual accountability? In our state, it's a felony to torture an animal, but not a person. That's what hazing is. It's bullying, manipulating, and torturing another human being. HB 993 takes out university presidents and national organizations, but it brings back the felony. You spoke, and overall, we listened to what you had to say last time we were here. I know that you said SB 440, that you're making it so that they can be charged with manslaughter and hazing, but speaking to at least 4 lawyers in our state, manslaughter charges are challenging to stick. We are literally living this right now, day in, day out. All the lawyers I've spoken with are in favor of this bill and its accountability factor. We have the support of the Interfraternal Council, the IFC, who represents 6,000 fraternities across the nation, and the National Panhellenic Council, who represents the sororities across our state. Both believe in individual accountability for committing these heinous crimes. Please reconsider making hazing someone to the point of death a Class 5 felony. Hold people who take the lives of another accountable for their actions.
Thank you. We do have a motion to conform.
Can I ask a question?
Yeah, Senator Sasslaw.
Is it, Delegate Murphy,
Yes?
is it okay if I add a drill instructor from Fort Hood, Texas, back in 1958?
Go right ahead.
I think that's a joke. Yeah,
I
Senator
think so
Norman.
too, but I'm just playing along here.
Senator Norman.
Mr. Chairman, I like the thrust of the committee, but does it, excuse me, of the bill, but does this still have that mandamus provision in there against college presidents?
No.
I want to hear it.
That's not in there.
Was that removed? I want to hear from the delegates, please.
Mr. Chair,
Yeah, Senator
the
Morse.
House
Yeah.
version took out the mandamus
We-
clause and kept the felony class 5.
I thank the delegate.
You're welcome.
Senator Morse. Senator Morse.
Thank you, Mr. Chair. Delegate Murphy, on
Who's talking?
line 10, you used the word haze. Would you give me an example of the most minor form of hazing to the most severe form of hazing, which I would think would include forcing people to drink copious amounts of alcohol? What would be the minor forms of hazing?
Well, I think minor forms of hazing, having been through it myself when I was in a sorority, make you wear humiliating clothes. I mean, there are a lot of minor hazing,
Okay.
which
Next question, Mr. Chair.
Senator Morse.
So if there was a minor form of hazing, say keeping somebody up in a wakened state for a long number of hours, and as a result of that, the person left the fraternity house, the sorority house, and due to their extreme state, deprivation of sleep, walked in front of a car and was killed, would that fall under the Class 5 felony of hazing?
I would have to ask an attorney for an opinion on that because I'm not an attorney.
Final
But
question.
We can
Senator
ask
Morse.
Charles
Senator
here.
Morse.
Under your bill, any form of hazing, though, that resulted in the death would be a Class 5 felony? Is that, I'm trying to decipher the lines on 13 and 14. Any person found guilty thereof of the offense that did result in death or serious injury to any person is guilty of a Class 5 felony. If death or serious injury was the result of even the most minor form of hazing, would that be a Class 5 felony?
Yes.
Okay.
Mr. Chairman.
Yeah, Senator Sorbo.
Thank you, Mr. Chairman. To follow up on Senator Morrissey's point, serious bodily injury is the same language used in the malicious wounding statute, which has been found for injuries as minor as a concussion or even some very minor touchings, if you really look at how the Court of Appeals has interpreted through the years. But, Mr. Chairman, we heard, I think, this bill for, I want to say, at least an hour in Crim Sub, and we took a lot of testimony about it. And I would move to conform the bill to the bill we passed at a session. In addition to that, I would note that I've received a lot of concern from several about the mandamus provision we left in against university presidents, and so I'd move to conform the bill minus the 2 paragraphs about mandamus. That'd be my motion.
Mr. Chair, substitute motion.
Yes, Senator Morse, the Boy Scouts.
I move that we pass the bill as presented today, the House version, and report and refer to Finance.
This is well, first of all, we had a motion to conform. This is a substitute motion.
To pass and to report and refer to Finance as it's being presented to us today.
First of all, we have a motion just to conform. Do we do that first?
Substitute motion
Okay.
to
Okay, substitute motion.
report the bill
Is to
as it's
report
being
the bill
presented.
as is. Is there a second? Okay, move to report and second. All in favor of the motion to report the bill as is, as it came over from the House, all in favor of the motion, vote aye. All opposed, no.
Ayes 7, noes 8.
Ayes 7, noes 8. The motion is defeated. We have before us a substitute motion to conform the bill as it left, the similar bill that left the Senate.
Bill did this.
Mandamus
Yeah.
provision.
With the mandamus no longer there. That's the motion. All in favor of the motion to conform the bill without the mandamus provision, say aye. Aye. All opposed, no.
Shame on you.
Motion carries. Is there a motion to report the bill, the substitute bill?
Re-refer to finance. I make that motion, Mr. Chair.
Been motion to report the substitute and re-refer to finance. All in favor of that, vote aye. All opposed, no.
Ayes 15, no 0.
Thank you, Delegate Murphy. Appreciate it. All right, the next Delegate Bourne, I'm just going down the list. Is he here? Delegate Hope, is he here? Huh?
Mr. Chairman, House Bill 614 from Delegate Bourne is identical to Senate Bill 747 from Senator McClellan. It reported from Judiciary 9-6 and passed the Senate 23-17.
I'd move to report.
Second.
Delegate Bourne's not here, but there's a motion to report the bill, which is identical to Senate Bill 474. All in favor of the motion, vote aye. All opposed, no.
Ayes 10, noes 5.
Okay.
Senate Bill 682 from Delegate Hope is similar to my Senate Bill 291. I like my version better.
Is there a
So I
motion?
move to conform the bill to Senate Bill 291.
All right. It's been moved. Is there a second to conform the bill to Senator Deeds Bill 296? All in favor is, so Delegate Hope's not here.
No.
All right, is there a motion to?
There's motion.
The motion is to conform. All in favor of the motion, say aye.
Aye.
All opposed, no.
Move to
Motion
report.
carries.
Second.
Been moved and seconded to report the conform bill, House Bill 682. All in favor of the motion, vote aye. All opposed, no. Motion carries.
Senator Norman has a motion.
Okay, Senator Norman.
Ayes 14, no 0.
Mr. President, excuse me, Mr. Chairman, having voted on the prevailing side of 614, there was reported 10-5. I've asked for you to consider that.
Second.
614.
The motion was to reconsider the vote by which Senate Bill 6, or House Bill 614 was reported.
This is Senator Bourne's bill. There was report. All right, is there a motion to
Been a motion and a second.
reconsider the reporting Senate Bill 614? All in favor of the motion, vote aye. All opposed, no.
Now I'd move to report the bill.
All in favor, is there a second? All in favor of the motion to report Senate Bill, House Bill 614 of Delegate Bourne's. All in favor of that motion, vote aye. All opposed, no.
Ayes 9, no 6.
9-6. The bill is reported.
Mr. Chair, the next bill on the list is House Bill 740 from Delegate Bell. And Delegate Bell, if this bill has to go to finance, if you don't mind, we could conform it to the Senate bill. Have you looked at that?
I have. Obviously, we have different approaches, and I would think this would be something probably to see if we could do in conference. There's a weird issue. The thing you steal is less than 1,000.
Absolutely.
The damage to the car is more than 1,000, but
Right.
it's not a vandalism, it's not a destruction charge, because it says you can't have a destruction charge if it's more than, in other words, you really have this not loophole, but this
We had-
strange gap.
We had the same discussion over
Right.
here, and we had two different bills that took different approaches.
We had 4, I mean.
I would move to conform the bill to Senate Bill 729. You'll recall that 729 included Senator Spruill's bill, and I don't remember that number, but there were two bills over here. It passed out of this committee 15-0, passed the Senate 40-0. And this is something finance has requested. I'd move to conform the bill.
Is there a second? It's been moved and seconded to conform the bill. All in favor of the motion, say aye. Aye. All opposed, no.
Then I'd move to report and re-refer to finance.
Okay, so second. Senator Morsi seconds. All in favor of the motion to report Senate Bill 740 and refer to finance, vote aye. All opposed, no.
Mr. Chairman, thank you.
Ayes 15, no 0.
Mr. Chairman, the next bill on the list is 744, which is also Delegate Bell. which is a bill identical to Senate Bill 122 from Senator Obenchain, which we also saw.
Yeah.
Well, this is a bill that the Finance Committee's requested.
Mr. Chairman, Ms. Shiflett is online. I know she did testify before, but if you're willing and able, she'd like to testify again, but if you're, I understand that committee's doing its
Probably
work.
just a minute at the most.
I'm sorry?
Probably just a minute at the most.
Okay, I don't know how to turn around, I'm just saying she's here. Taylor Shiflett.
Shiflett there.
And if you could repeat, Mr. Chairman, I'm not sure she can hear you, if someone could tell her that.
Please, Ms. Shiflett, we'd ask you to keep your comments to 1 minute, please.
Taylor Shiflett, would you please unmute?
Hi, can everyone hear me?
Yes, go ahead.
Okay. Hi, my name is Taylor Shiflett. I am the mother and the creator of Caleb's Law. I am before you today just as a reminder. I know that you guys heard my story before, but I want to be completely clear with all of you. A man violated my right to provide a life that I wanted so very badly. And that man is not being held responsible for that. My baby was big enough. He didn't need me anymore. If he wouldn't have been hit, if that vehicle that I was riding in wouldn't have been hit at the speed it was, my child would have survived in the NICU unit and he wouldn't have lost his life. Please help me move this bill forward to provide justice for other families when this will inevitably happen again. Thank you for your time.
Thank you, ma'am. Mr. Chair, you've got a motion to report and refer to Finance.
All right, all in favor of the motion to report and re-refer to Finance, vote aye. All opposed, no.
Or a substitute motion?
Is there a substitute motion?
I move that it be PPI.
Motion to pass the bill by indefinitely. Is there a second?
Second.
I've been moved and seconded the bill.
Mr. Chair, can I speak
Yes,
briefly?
Senator Peterson.
And I realize not everybody was here when we heard this a month ago, and I think it's important to note, and we heard Mrs. Shiflett's very heartrending and compelling testimony, but this would take the current felony statute, which deals with an intentional act to kill a fetus, in other words, directed at the fetus itself, and make it basically any type of action which was a wrongful action that inadvertently led to the death of a fetus, even if the perpetrator didn't know that the woman in the car was pregnant. And I just think that's a major extension of this law, and so I do plan to support Senator Saslaw's motion.
Mr. Chairman.
Yeah, Senator Bell, Delegate Bell.
Obviously, this did get reported last time. If individuals are contemplating a different action, may I have a brief
Yeah, sure, go ahead.
statement? Okay, so you did hear the commentary last time with respect to Senator Peterson. While it is conduct that may not be intentional, it does have to meet the standards for voluntary or involuntary manslaughter, which is conduct so gross, quantum, and culpable as to show reckless disregard for human life. And if you run into the back of an SUV and don't know there's a baby seat in the back and you kill the baby, it's manslaughter. That's not something that's... Now, the issue here is she wanted to have the child. She asked me to share a picture of the child with you. It would have survived in the NICU if it had been born in a hospital. And someone who was clearly committing conduct that would have measured up to manslaughter hit her, killed the baby. She wanted the baby. She had a hysterectomy. She'll never have another one. She is begging you to simply, and I understand it's an expansion, but to expand what we currently have for what would amount to first and second degree homicide to cover voluntary and involuntary manslaughter. Thank you, Mr. Chairman.
Mr. Chair,
Yes, Senator Peterson.
if I can ask a question of Delegate Bell, and
Yes, sir.
I appreciate this dialogue, but let me ask you this.
Yes, sir.
And that's clearly the most egregious case.
Sure.
Understood. But what if a woman is, say, 6 weeks pregnant and has a miscarriage as a result of an accident? Would that also qualify under the statute? Because it
Yes,
seems
sir.
to me that it would.
Yes, sir. And you would have to prove it. It would be an element of proof for the Commonwealth to prove that the miscarriage was caused by the conduct which reached this level. But yes, it does not have a date of, it doesn't have the date of the fetus included within. Yes, sir.
All right. Thank you, sir.
Yes, sir.
Let me ask you a question, Delegate Bell.
Yes, sir.
Personal injuries, in theory, could this be part of the damages in a personal injury case?
Are you asking, could there be civil recovery?
Yes.
I don't know the answer to that. I'm coming at it from the criminal angle. If counsel wanted to add, I'd be happy to take their expertise.
Okay.
Mr. Chairman, the
Yes.
answer is yes. If there's money, in this case, there would have been $0 available and no civil remedy.
Right, okay.
And Mr. Chair, she doesn't care about the money. She lost her baby. She'll never have another. And the guy doesn't get punished for that. Now, he was punished. I don't want to mislead for the injuries to her and the other driver, but no punishment for the baby. Thank you.
Okay, we have a PBI bill. The substitute motion to pass the bill by indefinitely. All in favor of the motion, vote aye. All opposed, no.
Ayes 8, no 7.
8 to 7, the bill is passed by indefinitely. Thank you.
Thank you.
Okay.
Delegate Bell, your
Yes,
next
sir.
bill is 749, which started out as identical to my 299. They took the finance part out of your bill, but the finance committee still wants it, and I don't understand that, but this is identical, or it's similar to 299. It basically has to do with funding for nurses that help investigate sexual assaults. The problem is we don't have enough of them, and they are concentrated in urban areas. So a lot of victims in rural areas have to travel long distances. And so the idea behind this bill was to provide more funding for those nurses. And the finance committee, we referred the bill that I had to the finance committee. The finance committee said they were going to include funding. I'm not certain if it's in the budget, but they didn't pass the bill. They want this bill, and I guess we have to send it up there, but the House took the finance language out of the bill. So I'm hopeful we'll get this bill out pretty quickly. So I'd make a motion that we report the bill and refer to finance.
I would second that motion.
Any discussion on the motion to report and re-refer to finance? All in favor of the motion to report House Bill 749 and re-refer to finance, vote aye. All opposed, no.
Ayes 15, no 0.
Delegate Bell, I
Thank you, Mr.
understand
Chair.
your House Bill 1198 is going to go by for the day.
Thank you.
1198 will go by for
The
the day.
next bill is House Bill 1306 from Senator Simon, and that's similar to Senator Evans' 643 that had to do with making Class 1 misdemeanor for altering a firearm serial number. It passed this committee 10-5, and it passed from the Senate 21-19. It reported to Finance. This bill doesn't have a finance marker. Or I don't have, maybe you do, Mr. Chair.
I think, yes, it's Delegate Simon. You don't want to be a senator, I'm sure.
Mr. Chairman, I am very, very happy where I am and enjoying my best life over in the House of Delegates. This does, I would have no problem if you all wanted to conform this to Senator Evans' bill. The difference is this bill has a reenactment clause on it. I think that the House would like to have a second bite at the apple. So if you guys want to conform it to, work it out in conference.
There's a motion to conform House Bill 1306 to Senator Evans' bill, Senate Bill 643. The motion, is there a second?
Second.
All in favor of the motion to conform, say aye. Aye. All opposed, no. Okay.
Now,
Motion
Mr.
carries.
Chair, I don't have the finance referral on my sheet. I'd move to report the bill.
Okay. Is there been moved and is seconded to report House Bill 1306? All in favor of the motion, vote aye. All opposed, no.
Ayes 9, no 6.
9 to 6.
Thank you, Mr. Chairman.
Bill is reported. Thank you.
Mr. Chair, the next bill on my list is House Bill 11 from Delegate Anderson. And that's not similar to anything we've seen yet.
Okay, concealed handgun permits. Delegate Anderson, House Bill 11.
Good morning. Members, the House Bill 11 seeks to decriminalize the first offense of concealed carry violations. Essentially, what we have in Virginia is a statutory scheme that a concealed carry violation is a Class 1 misdemeanor on a first offense, Class 6 felony on a second offense, and a Class 5 felony on a third offense. What this bill purports to do is make a first offense a civil penalty, second offense a Class 2 misdemeanor, and third offense or subsequent a Class 1 misdemeanor. This is basically lawful gun owners who are mostly caught up in a traffic stop, and the gun is somewhere it's not supposed to be. If it's in the glove box, it's legal. If it's under the seat, it's a crime. And so what's happening is Virginians are, and to be specific, over 2,339 Virginians in the past 2 years are being stopped, mostly in traffic stops. A gun's found under the seat. They don't know the rules, and it becomes a Class 1 misdemeanor. They're ineligible to get their permit during this process. So this bill basically says on a first offense for lawful gun owners who just simply have the gun in the wrong spot, it would be a civil penalty, and then they would also be eligible to go get their concealed handgun permit while that is pending for dismissal. Promotes compliance with the law. And I will say I have a chart. I talked to Senator Deeds about showing this, but basically the chart basically just says that 68% of Virginians are black. So it's dramatically disproportionately affecting the black community for these types of convictions. Not talking about criminals, but lawful gun owners. And I would hope that the committee would find it appropriate to report the bill.
Any questions? Do you have anybody want to speak in favor or against the bill?
Can I ask a question?
Yes, Senator Peterson.
And I want to thank the delegate. This is kind of an unusual approach because typically we get a constitutional carry bill to just get rid of concealed carry, lock, stock, and barrel, so to speak. This would basically make it a non-criminal penalty. So let's say somebody's in a situation where, you know, they're with a group of folks and police come up and do a pat down, do a Terry stop, and see one of them's concealing a weapon, and they have a weapon on them. And then there'd be a civil fine as opposed to a criminal fine, where, of course, if there's a crime, then they now have the ability to do a search and kind of go further. If it's just a civil penalty, I guess they're like, well, I'm writing you a summons for $50 or whatever. And effectively, they can't do a search. So in a way, isn't this putting police at risk a little bit if they can't arrest somebody for a concealed carry?
Well, so if there was in that specific situation, if you have a lawful gun owner who has a gun possibly maybe on their hip, like right here, but the jacket's covering it, and the police officer was to do a pat down over them, found the gun, the officer would be able to remove the gun, issue the summons, could still continue the pat down for other weapons or narcotics or anything else that would be there, and that would be it. I think that the issue is, and I didn't promote the constitutional carry. The issue is that most of these happen in traffic stops. Most of these, the gun is under the seat or in the door well, but our law allows it to be in the glove box legal. You don't have to have a permit in the glove box. So citizens don't know this until they're on the wrong side of it, and then when they get caught up in it, they can't even comply and go get their permit. So it corrects that defect.
Let me just ask one further question. I think some other folks may have questions. But you say a lawful gun owner. Well, of course, everyone's a lawful gun owner unless they're a convicted felon. And the only way a police officer is going to know if somebody's a convicted felon if they go back and run some type of data check on them. So while they're actually in the field patting somebody down and they come across a concealed weapon, again, that would be, at a minimum, a misdemeanor, a criminal offense. And if we take away that ability, and again, I can see arguments both ways, and this is a very interesting constitutional discussion. But I do think that if we passed this and made it a civil fine as opposed to a criminal fine, in a lot of ways, it's going to take away a level of policing that we've come to rely on. Now, there's, like you said, it cuts both ways. I get that. But I do think there would be, it would impact police behavior out in the field.
So I think for me, the big part about this bill is the part where you can go and apply for your concealed handgun permit while the charge is pending. And if it meant the bill dying as it is or reverting it back to a misdemeanor on a first offense, for me, the most important thing would be to let the gun owner go get their permit for a dismissal, which is not allowed under current law. So I would rather that happen than the bill not make it through, just for your...
Senator Short.
Thank you, Mr. Chairman. Mr. Chairman, I want to, the delegate's exactly right. I've had these cases. One of the first cases I ever had was a young black man who was a good citizen, had a good job, he'd been to the range. He had a gun under his seat because he'd been using it at the range. Officer stopped him for speeding, and he said, "Officer, I've got a weapon in here," and offered it to the officer because he thought he was doing the right thing. And he got charged with carrying a concealed weapon because it was under the seat. And that 9 times out of 10 is what happens. The citizen thinks that they are doing the right thing, and I think they are. by telling the officer that they've got a gun under the seat or something, give it to the officer, and they charge them with carry a concealed weapon. I'm really impressed with the delegate's approach on this, and I think it's a good bill.
Yes, Senator Morrissey.
Yes. Delegate, a couple of questions. Let me preface it with this. Senator Stewart gave you an example of what I would consider either a de minimis case of concealed or a not guilty case. Senator Peterson suggested a similar approach, but here's where I am on the fence. There are many, many cases where there are very weak cases of concealed. The person whose gun is on the seat and they come to a stop and it slides. It's open, it's visible. They hit the brakes and it goes to the floor and it's concealed. The gentleman or gentlelady who has a jacket that barely conceals it but does conceal it. The situation with Senator Stewart where they say, listen, I've got a gun here. They think they're doing the right thing. They may all warrant a civil approach. But what about the most egregious case of a concealed? Whatever you want to imagine, person who's up to mischief has got the gun in the back. It's definitely concealed. It's definitely an egregious case of concealed. Would your bill cover that situation as well, allowing for civil treatment for the first offense, as well as allowing that person who was certainly guilty of concealed to go and apply for a concealed gun permit?
Sure. Thank you, Senator Morrissey. So this person who's up to mischief could legally have the gun on their hip, and there would be no crime in that. So what you're talking about is basically having the gun behind them, which would be concealed. So it's the same gun, it's the same person, open carry legal, behind you a crime. And for the person that's in the mischief mode, or the person who has an intention to intentionally break the law, he could simply have it on his hip and that would be completely legal. But I'll tell you one other point. The Supreme Court just handed down an opinion this year and said that in a vehicle, if the gun is in a backpack and it's completely zipped, then there's an exception. That's a compartment exception the Supreme Court carved out. I'm not sure how they got there, but they did. But if a woman has a gun in her purse, taking that analysis, and it's not zipped up, then she would be in violation of the law. If it's zipped up, she would be in compliance. Unzipped, she wouldn't be. I think the thing is, the takeaway here is there's so many ways people can get caught up in this that they don't know, because when you buy a gun, you don't have to take a class. You don't have to know the laws. And they get caught up, and when they get caught up, now they're a criminal. Now they can't even comply and go get their permit. And that's what I'm trying to fix. I'm trying to fix compliance so that people don't become felons. A second offense ever in their life, second offense is a felony. Nowhere else in the code does that. Everything is usually within 10 years it becomes a felony. You get a concealed carry at 18 and then a concealed carry at 68, you're a felon. So I'm just trying to get compliance here.
Any further discussion?
Mr. Chair.
Yes, Senator Peterson.
And I kind of like the second part of this. I'm not a fan of the first part, as you can probably tell, so that I'll leave it at that. But have police chiefs or Commonwealth attorney, anyone in the law enforcement community had an opinion on this?
Senator, I know that the Sheriff's Association have been opposed to it, but they were, that's neither here nor there as far as I'm concerned, because I'm simply trying to.
Right. Okay, we need to move along. Anybody else would like to speak one way or the
Yeah,
other?
I'd like to.
Yes, Senator Peterson.
I'd like to hear from the law enforcement.
All right,
community
here,
on this.
law enforcement.
For those attendees in the Zoom room who would like to speak in support or oppose the bill, please raise your hand electronically now.
Okay, yeah. Who wants to speak? Next, okay.
Philip Van Cleve, VCDL. Yeah, we support the bill. In fact, our government's kind of centered around the idea that we would rather see a few people get off that were criminals as opposed to putting one law-abiding person incorrectly in jail. And we think this is a good compromise. Thank you.
Next.
Thank you, Mr. Chair. A couple of points that may answer some of the questions that we've heard here today. If someone is possessing...
Your name again, I'm sorry.
I'm sorry, Patricia Webb, Virginia Citizens Defense League, and I'm also a licensed FFL.
Right.
If someone is in possession of a firearm while in the commission of a crime, that's a felony, so that's a moot point on this bill. And to answer the senator's question about if they find a gun concealed in a pat-down, a Terry stop, When they write the summons, I would assume that the officer would run the license, and it would come up if they were a felon or had outstanding warrants. As far as laws, knowing the law when you buy a gun, laws change. You guys know this. One of the other traps is it is against the law. It's considered concealed carry if you carry a firearm that's deceptive in appearance. For instance, I have a little North American Arms .22 revolver. I wear it in a belt buckle. You actually need a permit to wear it like that. It's considered concealed because it's deceptive in appearance. So this relieves the liability if somebody doesn't realize that.
Okay.
Thank you for your
Thanks.
time.
Next person? Yeah, keep it short if you don't mind.
I'll try, Mr. Chair. Ramin Fadahi, Commonwealth's Attorney for the City of Norfolk. I'm here in opposition to this bill on my own behalf and on behalf of the Commonwealth's Attorneys of Albemarle County, Arlington County, and Fairfax County. This bill is a threat to public safety. It is a threat to public safety. It is harder to fall off a log than it is to get a concealed carry permit. An individual who is carrying a gun concealed is up to no good. One of the only good reasons at this point to make somebody a felon is to make them a prohibited person for firearms purposes. This is a legitimate crime-fighting tool that we use in our jurisdictions. To take away the ability to have this as a second offense when there is no confusion on the part of the individual about what his or her obligations are is going to lead directly to more violence in our jurisdictions. We ask that you vote down this bill.
Mr. Chairman.
Okay, briefly, yeah, come on up.
Mr. Chairman.
Senator Openshain.
I would ask the Commonwealth's Attorney from the Virginia Progressive, is that what it is? Progressive Commonwealth's Attorneys Association?
That's right, Senator.
So I take it that you aggressively prosecute these crimes?
I issued a policy about this crime about 10 days ago.
Aggressively prosecuting this crime?
Absolutely. I instructed my prosecutors that if they want to take a case like this under advisement, they have to get my personal approval.
Okay, yes, sir.
Mr. Chairman?
Yes, Senator Openshain.
Do they need your personal approval to take other cases under advisement?
Depends on the case, Senator.
Drug cases, for example?
Depends on the case, Senator.
Thank you.
Senator Stewart.
Thank you, Mr. Chairman. I'd ask the gentleman, based upon what he just said about these people who are up to no good if they're carrying a concealed weapon, do you instruct your officers to charge folks who offer the weapon to the police when they're to stop for speeding? If they say, "Officer, I just want you to know I've got a weapon in here"?
Senator, the police do not work for me and I don't work for them. The police chief issues directives about what to do.
Mr. Chairman?
Yes, Senator Stewart.
Do you prosecute those cases if individuals are charged and they notified the officer that they had a concealed weapon in there?
Yes.
Mr. Chairman?
Okay, Senator Stewart.
And how do you surmise that they are up to no good if they tell people, the officers, that they have a weapon in there?
It's better when they tell the officers than when the officers have to search for the gun. But what is the reason to carry a concealed weapon without a permit? I put that question to you.
Mr. Chairman?
Senator Stewart.
In fact, can't you have a weapon sliding around on your dashboard in a vehicle, and that's perfectly legal?
It is.
Mr. Chairman?
Yes, Senator Stewart.
Do you not think it's a better solution to secure that weapon somewhere so that it's not sliding around in a vehicle?
The law permits it to go in the glove box, in the trunk, or in a number of other places.
Okay. Senator Openshain, Senator Norman.
Mr. Chairman, one of the things I enjoy about the Senate is the collegiality and the respect. And sometimes advocates don't have self-awareness. And I got to say that your approach to this has probably flipped my vote from voting against it to vote for it. And it's strictly based upon your attitude.
Okay, next question. Anybody else want to speak one way or the other? There's one person. Yes. Laurie Haas.
Good morning, Mr. Chairman, members of the Senate Committee. This is an issue that needs attention. I'm not sure that this is the correctest solution. It is a bit disturbing to understand that concealed carry permit holders have violated the law over 2,000 times. Again, I respect the delegate and his attention to this because we don't want to overcharge. We don't want to prosecute. But again, if you have a concealed carry permit, why do you not know the law? Why do you not know that you're supposed to store your firearm? And why do you not know what the rules and the laws are in the Commonwealth of Virginia when you're carrying a firearm, which is a deadly weapon, which puts our law enforcement at risk? So I'm speaking against the bill because I think there needs to be a better solution. I think we need to look at the bill, look at the consequences, and look at what it's doing to our public safety and the landscape that our law enforcement find themselves in when they're faced with a person who possesses a firearm.
Mr. Chair.
Thank you.
Mr. Chair. Mr. Chair. It's not often I don't think I'm a puppet of Ms. Haas, but I think we're going to agree on this one. Delegate, this is a very good conversation. I thank you for bringing the bill. I think I'm going to move to pass this bill by indefinitely, and I do think we should take this up next year. I think there's a lot of issues here in terms of how this law is applied, how consistently it's applied, the safety factors. We do have a locked trunk exception. We do have a locked glove box exception, which I voted for years ago. I'm just not ready to support this right now, so I am going to PBI the bill, but I do appreciate the conversation.
Motion.
Speaking to the motion, Mr. Chair.
Does somebody else want to speak?
Mr. Chairman, there's one person online.
One more person to speak.
Vic Nichols, would you please unmute and begin your testimony?
Thank you. People most hit by concealed carry issues are usually young African American and Hispanic males. What you're doing is adding more jail time to them. Okay. So, if you want to talk about a prison to pipeline, here you're making it worse. This bill makes it better. And about the laws, when every city has its own different issues and stuff like that, you're expecting basically for concealed carry holders to become lawyers to know exactly who's what, where. Can I move it 5 inches from my hip to my back? Go it over. This is the kind of minuteness that we're addressing, and it's only with lawful gun owners. Okay. And the other thing, if y'all ever been to Portsmouth, to P-Town, I'm here to tell you, most people there do not know. They will sit there and say we're packing, we're carrying, or anything else, and they're not aware of the laws.
Okay, thank you.
We're trying to fix it.
Is there a motion? Senator Morrissey?
Thank you. First of all, Delegate Anderson, I too want to thank you for bringing the bill. I think Senator Peterson is right, though. It needs more study. And let me just say this. There's 2 things that we're doing here. One, we're discussing whether or not shall I call a classic case of carrying a concealed weapon where the person is guilty should be able to avail themselves of civil treatment. The other thing that we're conflating is what Senator Stewart has brought up twice now, the case where somebody really, in my opinion, and perhaps others, is not guilty of carrying a concealed weapon because of a myriad of circumstances. It's for that reason and an additional study that's necessary that I'm going to support Senator Peterson's motion to PBI and to second it, but I do appreciate you bringing it.
Been moved and seconded to pass the bill by indefinitely. All in favor of the motion, vote aye. All opposed, no.
Ayes 10, noes 5.
Mr. Chair, the next bill on the list is House Bill 104, also from Delegate Anderson.
Members, 104 is probably the most important bill that I've carried this year. So it deals with statutory speedy trial. Speedy trial basically, statutory speedy trial says that from the date of indictment or the date of probable cause finding, defendant has to be tried within 5 months if they're in custody or 9 months if they're out of custody. Two things have happened to the criminal justice system in the past 2 years. One, the pandemic, and 2, the new jury trial judge sentencing bill that has come into place. Both of those have created pressures on the criminal justice system. More have come from the pandemic than from the jury trial judge sentencing, but what we have is a bottleneck and a pipeline of cases. Right now, Virginia is under a judicial emergency. We've been in a judicial emergency 35 times since the beginning of the pandemic. And the judicial emergency is suspending statutory speedy trial. But the train has to end. The Supreme Court is going to have to end this judicial emergency at some point. And when that happens, the clock starts running. 5 months in custody, 9 months out of custody. Here are just a couple statistics. In Virginia Beach, there are 130 jury trials on deck. They've never had more than 60. Alexandria, they had 46 jury trials on deck in 2020. They have 583 now. What this bill basically is going to do is it's going to allow the courts to set cases outside of statutory speedy trial to the most reasonable date that possibly can be set so that the criminal justice system can operate effectively. It has a sunset clause in 2 years. It's just to get over this pandemic and adjust to the new procedures that the General Assembly has placed on the criminal justice system.
Any questions of anybody on the panel? Do you have any speakers?
I do.
For those attendees in the Zoom room who would like to speak in support or opposition to the bill, please raise your hand electronically now.
Okay, you got one speaker.
Apologize, Senator, I didn't know if you wanted to go to the virtual world first or us, but
You go ahead.
my name is Nathan Green. I'm the Commonwealth's Attorney for the City of Williamsburg, and I'm here speaking on behalf of the Virginia Association of Commonwealth Attorneys. Mr. Chairman, this bill is absolutely needed because when that judicial emergency is lifted, we have more jury trials scheduled than we have days in the year. I did provide Delegate Anderson with the information about Alexandria, and I want to correct it. I do apologize. There's a couple numbers that were there. The real numbers are, in 2019, they scheduled 49 juries that took up 88 days. In 2022, in Alexandria, they have more than doubled that. They have 101 juries scheduled that was as of November of 2021. They had 101 juries to be scheduled in 2022, and that took up 500 days. They have moved to setting, they have 14 juries that are set for 2023 because they just don't have the days in 2022. And again, that was as of November of 2021, 60 days before the year even started. Throughout the Commonwealth, we did ask prosecutors to give us some insight as to what their jurisdictions were facing. What we found out, we got 33 responses to the survey, and in those 33 responses, in those jurisdictions, there were 2,000 juries scheduled in 2019. In 2021, November of 2021, there were already 2,367 juries scheduled for 2022. So more juries were scheduled before 2022 even started than there were in all of 2019. Obviously, I'm disregarding 2020 because of the pandemic. That was just an incredibly off year and hard to understand exactly what the delays were with that. But every jurisdiction is struggling with having enough criminal days to satisfy the number of jury requests.
Sir, don't you believe the Supreme Court's in the best position to make these decisions?
Well, as far as whether the judicial emergency should end, absolutely. But I do believe that the judicial emergency will end. And then we are going to be back to, we have to find 583 days in a calendar in 5 months. And there just aren't 500 days in 3 months, in 5 months.
Senator Sherwood has a question.
Thank you, Mr. Chairman. Mr. Green, good to see you again. When I talked with the delegate about his bill before it came here, and he talked to me about the backlog of Virginia Beach. I called the chief judge in Fairfax and asked her when I could get a civil trial date in Fairfax. She told me next month. Do you have any data from other jurisdictions besides the city of Alexandria in Northern Virginia?
I do. I have it from 33 jurisdictions. I don't have it from, I don't have Fairfax.
Okay. Additional question, Mr. Chairman.
Yes, Senator Sherwood.
I read the fiscal impact statement on this bill, and according to the Indigent Defense Commission, they estimate that this would require an appeal of every single case they take to trial. They said somewhere between 5 and 50% of their cases, depending on the jurisdiction, which of course would increase the Attorney General's appellate load, which we just read in the paper today, that apparently they can't handle what they already have, although in this fiscal impact statement they said they can handle it. I'm just trying to understand how you think that whole scenario might cause problems for your office, given that we're creating a sort of a constitutional speedy trial problem in every single case if we were to pass this bill that would go to the Court of Appeals that somebody would have to handle. I'm not clear what the situation is, given all the public statements that are out there.
Senator Serval, may I answer that just for a second?
Yeah,
We
Delegate
addressed
Anderson.
we addressed that issue in the committee in courts, and so we took out the interlocutory appeal and made it just a motion, and that is similar to how bond appeals are done. The Indigent Defense Commission modified their fiscal impact to where there's an unknown fiscal impact now. So I think we've streamlined it, and that was done in the substitute.
Additional question, Mr. Chairman, thank you. But my question, Mr. Green, is doesn't that give you a concern about the viability of your cases if every single case is now going to have a speedy trial appeal because we changed the law right in the middle of the case?
Mr. Chairman, if I could respond, I will push back on every single case. This is not a tool, while I'm up here arguing for it, this is not a tool for prosecutors. This is a tool for judges. It is the judge who makes the decision about whether they have the days or not. I do not get to ask for the case to be set outside of speedy trial. I go to the court and I say, Judge, we are ready for trial. Please give us a trial date. And the judge says, I don't have any days in the next 5 months. The soonest day I can give you is outside of that 5 months. I don't think that will happen in every case, but when it is necessitated, it's necessitated, and we will need the extra time. But again, I want to make it very clear, this is not the prosecutor's motion to go outside of speedy trial. This only happens when a circuit court judge appointed by the General Assembly says in full good faith, I do not have the days to get this scheduled within 5 or 9 months. That's the only time it could happen. It will not happen in every case. It will only happen when necessary, and who decides it's necessary is not the prosecutor, it's the judge.
Mr. Chairman, one final question.
Yeah,
one quick.
Very quick. We need to move this along.
Okay. Mr. Green, have you done any correlation to see how many of these backlogs are in jurisdictions that don't have drug courts, mental health courts, or other diversion programs? Like, for example, the jurisdictions I tend to practice in that don't seem to have the backlogs you're talking about?
Well, Alexandria has the most robust diversion programs, and they are the ones that we brought up because they are one of the jurisdictions that are presently, well, not presently, I don't know when they're doing it presently, but in November, they were starting to schedule jury trials. Not in 2022, but in 2023.
Okay.
And so that's,
right.
Alexandria has one of the most robust diversion programs.
Senator Stewart.
Thank you, Mr. Chairman. Nate, I understand the need for this and the importance of it, but I have a more practical question. Can this body, through this bill, essentially bypass the Constitution, which guarantees a speedy trial?
Mr. Chairman, no, you cannot. There is always going to be constitutional speedy trial. This does not affect constitutional speedy trial. And as a matter of fact, in the bill it talks about, this does not affect constitutional speedy trial. But this General Assembly, well, not this General Assembly, the General Assembly put statutory speedy trial as a partner to constitutional speedy trial. This is affecting statutory speedy trial, which is the 5 months and the 9 months. It does nothing to constitutional speedy trial. And if someone could still make the constitutional argument that I needed to have my trial within 5 months, well, then they can prevail. This only affects the statutory scheme that calls for the trial within 5 and 9 months.
And we have a number of people, we need to move this along. Senator Morrissey.
Good morning, Mr. Green.
Good morning.
The statutory speedy trial, 5 months if you're locked up, 9 months if you're not, has existed since the Constitution was amended, what, in 1902 or 1951?
That I don't know the answer to that. Right. Mr. Chairman, I apologize.
Further question.
Senator Morrissey.
In any event, whether it's 120 years or 70 years, we have been able to deal with a statutory law that required a trial to be commenced within 5 months if the person was locked up, right?
Mr. Chairman, that is accurate. Okay. Mr. Chairman, something happened in the past 2 years that has changed our ability to do that.
Let's call it a pandemic.
Mr. Green, what about, I understand a judge may say my docket is full, but why can't they do what is done every day in every judicial circuit in the state, bring in substitute judges, particularly now, to unclog the system?
Mr. Chairman, sometimes it's not a matter of judges, it's a matter of courtrooms. Many jurisdictions only have one courtroom, and so you could give them 5 more judges. But unless you give them 5 more courtrooms, they cannot accommodate the number of juries that are being asked for in certain
We need to
jurisdictions.
move this along. There are 3 people that want to speak virtually, very quickly. Each one gets 30 seconds. I think we understand the bill.
Anton Bell, would you please unmute and begin your testimony?
Good morning, sir, Chairperson. I'm from Hampton, Commonwealth Attorney, and I just want to make sure that the panel understands that right now, currently, we have 334 juries that are pending from February 2022 to March 2023. In addition, within the next month, we have 38 juries currently pending. As a result of that, we only have 3 judges, and we have 1 unfunded judicial vacancy. And we do not have the ability to be able to try these juries. We are setting juries right now, 3 and 4 juries stacked on each other. Okay. As essentially what we're dealing with is every month there's going to be about 3 or 4 juries that's not going to be tried each week. Okay. And so we need this bill.
Yeah, thank you. We get the point. Next person.
Howard Glenn.
30 seconds. We got to move this along.
Howard Glenn, please unmute and begin your testimony. Howard Glenn, would you please unmute and begin your testimony? Vic Nichols, would you please unmute and begin your testimony?
Yes, we need to get government moving. This one way to do it. Thank you.
Okay. Now, yes, somebody want to speak against the bill? Want to speak? Okay.
Good morning, Mr. Chairman, members of the committee, Maria Jankowski, Virginia Indigent Defense Commission. I'm not speaking against the bill, but I do feel I need to push back a little bit on what Mr. Green said, which is this won't be in every case. I do not feel like we will be able to just let a tolling go. I think we will have to object to it, and I think we will have to memorialize it, and I think we will have to do an appeal or a motion in any instance in which speedy trial is tolled, because I do not think that the case law in Virginia allows us to sort of draw these very neat lines between constitutional and statutory speedy trial. And our fear will be we will not have adequately preserved our clients' constitutional right to speedy trial if we let this go without noting an objection, without memorializing it and preserving it in any way we can. And unfortunately, the case law in Virginia has been that the courts have said if it didn't violate speedy trial, statutory speedy trial, it in all likelihood did not violate constitutional speedy trial. And it's that space in which we have a concern, which, and again, I'm not taking a position on the bill, but Mr. Green's representation that this won't be in every case, I don't know that we can say that this won't be in every case.
Okay, thank you. Appreciate it. Is there,
Mr. Chair?
Yeah, Senator Obenchain.
Just a quick question. We heard from Mr. Green with the Virginia Association of Commonwealth Attorneys express his support for this. I wonder if this is also supported by the progressive Commonwealth attorneys as well.
Well, okay. We've
the Norfolk Commonwealth attorneys here.
Fine. If he wants to speak, he can. Is there anybody else need to speak? Is there a motion? We need to move this along. We need to move this along quickly. No
Mr.
position
Chair.
said.
So they don't oppose it.
Great. Is there a motion? Is there a motion?
Where's the Supreme Court on this?
Well, is there a motion?
Move to report.
It's been moved. Senator Stanislaw has a substitute motion to pass the bill by indefinitely. Is there a second? Second. All in favor of the motion to pass the bill by indefinitely, vote aye. All opposed, no.
Ayes 9, no 6.
9 to 6.
Mr. Chair, the next bill on the list is Senate Bill, or House Bill 117 from Delegate Kilgore. And this bill simply puts the bar examination back where it was maybe 45 years ago.
Right.
Where you can take the bar exam in your last semester of law school.
Right, and this comes from the, this is a request from the Board of Bar Examiners, and Delegate Jay Jones was supposed to carry this bill, and he had to transfer it over to me, so that's why I'm carrying it. So that's all it does is you're able to take it. Some people, you don't have to take it. I mean, like Steve Benjamin could probably do it and pass, but you know, folks like February,
Yeah, this is the way it used to be years ago when I took the bar.
So that's what it does. It just allows you to do it, and it's because of student debt and things of that
Is
nature.
there any discussion?
Senator Morrissey.
Senator Morrissey?
Delegate Kilgore, in a moment, I'm going to make a motion to pass it by, but I just wanted to express my personal condolences, and I think I speak for the body. You lost your father recently, and we all want to express our condolences.
Thank you.
With that, and in unrelated, I move to pass the bill.
It has been moved and seconded to.
Move to report.
The bill, Senate Bill 117. All in favor of the motion, vote aye. All opposed, no.
Thank you, Mr. Chairman.
Ayes 15-0.
15-0. Okay, the next one, moving in order, is going to Senator Deeds.
The next bill is Senate Bill 711 from Delegate Keem, and what it simply does provides that the petitioner for a writ of vacatur for victims of sex trafficking not be required to pay any fees or costs for filing the petitioner. It passed House without opposition.
Delegate
I move to
Keem's not
report the
here.
bill.
Been moved and seconded to report House Bill 711, writ of vacatur. All in favor of the motion, vote aye. All opposed, no.
Ayes 15-0.
Motion carries.
Mr. Chair, the next bill is House Bill 808 from Delegate Price. And this clarifies that a fee of up to maximum of $5 may be charged by an employer.
Yes, thank you, Mr. Chairman and Senators. If an employer wants to charge for withholding child support payments from an employee's check, current law states they can charge a $5 fee. By adding these words, it would just clarify they can charge up to $5, but less if they wanted to.
All right. Yeah.
Move to report.
All in favor of the motion to report the bill, vote aye. All opposed, no.
Thank you, Mr. Chairman.
Ayes 15-0.
Next, we have 4 bills left on the docket. 2 of them are from Delegate Leftwich, and one of them is going to require a little discussion. If you don't mind, we can take up the others first. Delegate Sullivan has House Bill 1285, repeals the sunset provision on the Supreme Court's authority to adopt rules assessing members of the state bar an annual $25 to be deposited in the client's foundation fund. And I assume that this bill was requested by the Supreme Court.
It's requested by the State Bar, Mr. Chairman.
Okay.
And you've described it well. It simply removes a sunset. This fund was set up by this body, and we want to preserve the Supreme Court's ability to charge a fee to each lawyer. This is not general fund money. This comes from the lawyers. The fee is currently $5. Each of you pay $5 a year.
Been moved and seconded to report House Bill 1285. All in favor of the motion, vote aye. All opposed, no.
Ayes 15-0.
Mr. Chair, Delegate Bell has House Bill 1352 that prohibits elementary or secondary school from retaliating in any manner against any individual who in good faith reports child abuse or neglect as mandated by the law.
Mr. Chair.
Have there been instances where that's occurred?
Yes, they were brought to me that it has. I'm worried about unintended consequences, which is why I asked it to be sent to Judiciary. I would like to have staff look at it before it comes up, so if it's the chair's willingness to just put it to your next meeting, this is trying to do due diligence on a tiny bill to make sure it doesn't do something bigger in a negative way.
House Bill 1352 will go by for the day.
And Delegate Leftwich is next. House Bill 1066, which removes the exception to the notice of probate under current law that allows such notice to be given when assets passing under a will or an intestacy do not exceed $5,000.
Is there anybody opposing the bill?
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, there are no hands raised.
Looks like there's no opposition in the House.
I know when to keep my mouth shut.
Where did the bill come from?
This came from the State's Bar.
State Bar?
Yeah. There was a due process question as to whether people entitled to even a penny should not get notice.
Oh my gosh, it came from the Virginia Bar Association Will Trust and Estate section. Ooh.
Mr. Chairman?
Yes, Senator who?
Had we picked 5,000, because
isn't 15,000 the number where small states pass through?
Yeah, who's the question?
Mr. Chairman, members of the committee, the exemption is in place now. This would remove the exemption because there are due process issues with the exemption being in place. Jim Cox from the Virginia Bar Association is on the Zoom if there are questions for a wills and trusts practitioner, if that's helpful.
Okay, would like to speak on Zoom?
Could I get the name?
James.
State your name, please.
Expense for the estate, maybe a small estate.
James Cox, would you please unmute? James Cox, would you please unmute?
I'm unmuted now.
Yes, go ahead, James Cox. House Bill 1066.
Thank you, Mr. Chairman. The concern the Bar Association has on the existing exemption of $5,000 is that there's circumstances where people, especially pursuing administration of suits, might qualify for the $5,000 exception, and then it turns out that there are great numbers of dollars that are at issue in the estate. We think that the beneficiaries and the possible heirs should be aware of that. There's also a concern that somebody could qualify in one jurisdiction as an administrator for general purposes, and then another person qualify later for wrongful death purposes, and that possibly second qualification would be invalid and could cause problems for the prosecution of that suit. In general, we also have concerns about the due process issues because originally this was set up back in 1991 as as an exemption for $5,000, but we think that really there should be no de minimis exception for an estate notification that something's going on that may affect people's substantive rights.
Mr. Chairman?
Yes, Senator Obenshain.
And I would note further that many of these quote-unquote small estates may have other assets that are not passing through the estate that may be of significant concern to the beneficiaries, bank accounts with survivorship and other things, houses. This is a great bill.
Okay, anybody opposing the bill? Is there any further discussion? Is there a motion? Been moved and Senator Obenshain seconds to the motion to report the bill, House Bill 1066. All in favor of the motion, vote aye. All opposed, no.
Ayes 15, no zero.
15-0. The motion carries. I think we have one final bill. House Bill 1080, Delegate Lefwich.
All right, this is the emergency shelter bill. I spoke with counsel. I think he said the intent of the committee or some folks was to conform that to language that existed or was approved by the Senate several years ago.
Yep. Mr. Chair, so in 2019, Senator Cosgrove and Delegate Lefwich carried two bills. The Senate Judiciary Committee had a substitute which reported out of this committee 14-0 and passed the Senate 40-0. I do have copies of the language that could be passed out, but that would be one way to put this in a posture where there is no opposition to the Senate position.
Is there a motion to...
Can we see? It's been a long time since 2019.
I can pass, it's not that long, but I can pass it out. It might be easier.
Yeah, why don't you pass it out? Yeah, Senator Morrissey.
Mr. Chair, while it's being passed out, I have a question of the delegate. Delegate Lefwich, I'm mindful of how this passed out of the House, but can you tell me what the genesis of this bill was? Was there a problem when somebody entered an emergency shelter because of freezing temperatures or flooding that they did not report their status as on the SOR list?
So this bill originally came to me through my city's legislative package several years ago, which is why both myself and Senator Cosgrove carried it. And it was requested by the city through a request from our chief of police. who was running the shelter. And I don't know what exact circumstances may have arisen during that fact pattern, but because I just.
Further question, Mr. Chair.
Yeah, Senator Morrissey.
Thank you. Delegate Leftwich, so as I understand it, if an individual enters an emergency shelter, say it's freezing temperatures, and we've all seen the situation where there's a state of emergency and the police sometimes round homeless people up and bring them to the shelter. Somebody enters an emergency shelter because of whatever the emergency is, as soon as they warm themselves up, as soon as practical, they've got to go to the individual who was running the shelter and say to them, oh, by the way, I'm on the sex offender registry list. Is that right?
Yes.
Okay.
And if they don't do that, they're guilty of a crime.
Well, my bill has as a Class 3 misdemeanor, the substitute that council passed out strips the penalty out.
Okay.
And my bill also, in working with some of my colleagues actually across the aisle in the House, included a provision that stated that the disclosure of that by an individual would not be disclosed to anyone else in the shelter unless required by law. So that part of my bill I thought was a good addition, which is not in the Senate substitute. But again, I'm happy to, I mean, if the committee's going to look favorably upon the bill, I'm happy to try to work things out in the conference.
Mr. Chair, I move to conform the bill to,
Moved and seconded to conform the bill. All in favor, say aye. Aye. All opposed, no. Motion carries.
and that motion was the adoption of the substitute.
Yeah, the motion has been made to report.
Report the substitute.
To report the substitute. Yes.
Mr. Chair?
Senator Boyce.
Thank you. How would a person know that they were required to report that they are on a sexual?
That'd be part of the, I'm sorry, part of the rules they release.
And so would they be individually contacted and?
So as I
told
understand
that,
it,
or-
there's a whole host of things that these folks are required to do, like notify law enforcement of a change of address or where they're living. And this would be one of those things that's included in that notice that they're given.
Senator Dees.
Senator Voisko, when a person convicted of a serious sex offense, there's all sorts of things they have to comply with, and they are given that notice, and they're required to march in a straight line and stay registered with the state police and let them know about any changes that occur in their life. And also report periodically whether there are changes or not. So this is something that somebody who's convicted of one of these offenses is going to know.
Okay. Any further discussions?
Yeah.
Senator Peterson.
And with deference to my friend from Chesapeake, who's really an outstanding attorney, and I really liked his last bill. I've never liked this bill.
No.
And I just assume PBI it here and not let it straggle forward. I just, at some point you got to have God's grace, and I don't like the intent of this bill, which when people are in dire circumstances and are in an emergency shelter, that they have to go find someone and report themselves as an RSO. I think they're, at some point God's grace says, we're gonna take people as they are. And I just have never once heard any specific incident of somebody being put in harm's way by this type of situation happening. So I'd make a substitute motion to PBI with all due respect.
And moved to PBI the bill. Is there a second? Second been moved and seconded to pass the bill by indefinitely. Any discussion? All in favor of the motion, vote aye. All opposed, no.
Ayes 7, noes 8.
Okay. Been moved and seconded to report the bill, the substitute. All in favor? Yeah. Moved and seconded to report the bill. All in favor of the motion, vote aye. All opposed, no.
Ayes 9, noes 6.
9-6, the bill passes. Okay, thank you, Delegate Leftwich. Without any further discussion or activities, the Senate Judiciary Committee is adjourned.